A multinational marriage is not only a personal relationship between two individuals. It is a legal intersection of jurisdictions, assets, currencies, and legal cultures. What most couples are not told is that marriage quietly activates multiple legal systems at once. In a domestic marriage, a single legal framework usually applies. In a multinational marriage, several laws may compete for relevance. A prenuptial agreement is often the only instrument that imposes order on this complexity. Many foreigners assume that the law of their nationality will control marital assets. Others assume that the law of the place where assets are located will prevail. In reality, different aspects of marriage may be governed by different laws simultaneously. How Vietnamese law interacts with foreign legal systems. When a marriage is registered in Vietnam, Vietnamese marital law applies by default. This includes classification of assets, income, and liabilities. Foreign legal concepts do not automatically override Vietnamese statutory rules. Prenups as a conflict management tool. A well-drafted prenuptial agreement does more than allocate property. It anticipates conflicts of law before they arise. It clarifies which rules apply and where ambiguity would otherwise exist. What most prenups fail to address. Many prenuptial agreements focus narrowly on asset division. They overlook jurisdiction enforcement and cross-border recognition. In multinational marriages, these omissions are often where disputes begin. Enforceability is not universal. A prenup that is valid in one country may be unenforceable in another. Vietnamese courts evaluate prenuptial agreements under Vietnamese law. Foreign validity alone is not sufficient. The problem with generic international prenups. Some couples use international templates designed to work everywhere. In practice, these documents often work nowhere. Without local compliance, they risk being symbolic rather than effective. Foreign assets are not immune. In multinational marriages, assets are often spread across jurisdictions. Overseas property, foreign bank accounts, and international investments feel distant. Legally, they are not. How asset location can create false confidence. Foreigners often believe that assets held abroad are beyond Vietnamese jurisdiction. While enforcement may differ, classification does not always follow the same logic. Without a prenup, disputes can still arise even if enforcement is complex. Business interests face multiple layers of risk. For founders and investors, business equity often spans several countries. Marriage can affect ownership, voting rights, and profit distribution. A prenup is often the only document that aligns marital law with corporate reality. What happens in divorce is only part of the story. Most couples focus on divorce when discussing prenuptial agreements. In multinational marriages, death and succession can be even more complex. Inheritance laws vary widely and often interact poorly with marital regimes. Prenups and estate planning must align. A prenup does not replace a will, but without coordination between the two, estate plans can unravel. This is rarely discussed until it is too late. Cultural assumptions create legal blind spots. Different cultures view marriage, property, and financial independence differently. These assumptions influence behavior but not legal outcomes. Prenups translate cultural expectations into enforceable structure. Why courts care about fairness and consent. In cross-border cases, courts often scrutinize prenuptial agreements closely. They assess whether both parties understood the agreement and consented freely. Language barriers and power imbalance become legally relevant. Translation is not a technicality. In Vietnam, bilingual documentation is often essential. Poor translation can undermine consent and clarity. What seems minor on paper can become decisive in court. The illusion of flexibility. Many couples believe they can adjust arrangements later if needed. In multinational marriages, later adjustments are harder, not easier. Legal systems become less flexible as facts accumulate. What a strong multinational prenup actually does. It defines property regimes clearly. It anticipates jurisdictional overlap. It aligns marital arrangements with business and estate planning structures. Most importantly, it reduces uncertainty across borders. The real cost of not knowing. The greatest risk in multinational marriages is not bad faith. It is incomplete understanding. Legal systems do not correct misunderstandings. They enforce rules. Final insight structure enables stability. Prenups in multinational marriages are not about pessimism. They are about respecting legal reality. When multiple jurisdictions are involved, clarity is not optional. It is essential. Cross-border clarity starts early. If you are entering a multinational marriage involving Vietnam, do not assume that one legal system will quietly solve everything. When jurisdictions overlap, uncertainty multiplies. A properly structured prenuptial agreement, drafted with Vietnamese enforceability in mind, is not a luxury. It is a risk management tool. LTS law advises foreign investors, executives, and expatriates on cross-border marital agreements aligned with Vietnamese law, corporate structures, and estate planning strategies. Visit lts.com.vn to schedule a confidential consultation. In multinational marriages, stability is never accidental. It is designed.